Hello, good evening and Happy New Year to all. 2024 po tayo ngayon. Okay, yung pong sa thumbnail natin, yung katanungan po ito, galing po ito kay Orlando de la Rosa. It was posted 2 weeks ago doon sa comment section ng ating mga public subscribers. No? Nasabi niya, Attorney, good day, ano po ba ang pwedeng gawin sa deed of absolute sale na hindi na notaryo? Pareho na pong patay ang tita ko, yung seller, at ang father ko, the buyer. Pwede bang bawiin ng mga heirs ng tita ko yung titulo na nasa amin? Maraming salamat po. At sabi ni Human Nature, wait din po ako sa sagot ni Attorney tungkol dito. Human Nature is one of our avid subscribers here, no? And commentator sa ating live portion. Okay, thank you so much for that, Orlando de la Rosa, no? Well, basically, based on your question, I will just answer in general terms, no? Because hindi man natin nakita ang total scenario. Hindi ko nakita ang both sides of the scenario. No? However, now, we are going to talk about a deed of absolute sale na hindi notaryado. Now, is it a valid document still, kahit na hindi na notaryo? And the answer is yes. Because sa deed of sale, hindi po kailangan na ang form is kailangan siyang in public document. Unlike sa deed of donation, na strict ang requirement ng batas, sinabi doon is kailangan in public document, no? In writing, in public document, and accepted by the donee. Pag hindi po siya in public document, void po, no, si deed of donation. Pero sa sale po, hindi. Kahit anong form of sale transaction can be done. No? There are instances nga, kung niya, received the amount of 50,000 as payment of a parcel of land covered by title number, etc. That would be considered as sufficient, no? Evidence that there was a sale between the parties. Merong bentahan. So, sa situation po ninyo, meron po, no? However, ang rule is that it is not a public document. It is just a private instrument. Ano ibig sabihin ng private instrument? Now, kung sakali pong magkakaso sa korte, hindi katulad sa public document. Pag magkorte ka, on the rules on evidence, you present mo na lang yung dokumento na yun, yung notarized deed of sale. It is a public document. You don't need to call the lawyer, you don't need to call the witnesses, the parties, because it enjoys the presumption of regularity by the notary public na notaryado ito. It's a public document. It can be accepted as evidence immediately by the court. Pero kapag private instrument, katulad nitong deed of sale, kailangan po ng witnesses to prove it, no? And I would say two-witness rule, no? At least two witnesses would identify, number one, na talagang nakita niya nagpirmahan yung mga bentahan ng property. Second, nakita niya nagpumirma, no? At nagkaintindihan sila doon sa paggawa nito. And the witness must be, at least sana, nandoon siya sa deed of sale as witness. Yan. Yun ang pinakamaganda yan. Nakalagay yung pangalan niya doon na witness sila. Kasi kung sila lang dalawa, tapos hindi siya nakapirma doon as witness, then sabihin niyang, witness ako, nakita ko, I was there when they signed this, it would be subject to some opposition, no? Maraming pamamaraan ng pag-oppose na, you're not there. Dapat kung witness ka, nagpirma ka sana, di ba? But you were not there, so how could you be witness? Pwede siya i-question, no? Kaya, sabi ko, pag private instrument po, pag hindi nyo na notaryo, automatic po magpalagay kayo ng dalawang witness. I-print ang name, address, doon sa document, papirmahan. Para, yun talaga, in case magdating ang time na kailangan siyang i-prove in court, no, as to the genuineness or authenticity. Authentic ba yung transaction nila? Kailangan ng makita mo na kung saan ang address ba, tawag mo na, papasomon mo na, pasupina mo. Tawag po ng supina niyan is supina duces tecum. Yung pagsabihin, duces ad testificandum. Dalawang klaseng supina sa court. Supina duces tecum and supina ad testificandum. Yung supina duces tecum, you're commanded by the court to come over and bring some documents. Usually, yung mga sa police blatter, mga ganyan, no? Dalhin nila yung blatter sa court para to compare, no? Yung subpoena ad testificandum, ibig sabihin, you have to testify in court. So, if that witness is listed as one of the witnesses in the deed of sale at nagpirma siya doon, then papatawag siya through subpoena ad testificandum. Oh, totoo ba yan? Nung nagpirma sila, nagkakaintindihan sila, tatanungin sila ng korte niyan to satisfy. No? So, yun lang ang difference. But it's still a valid document, Orlando, no? If it is, there is a sale, no? Now, there is also one kind of sale wherein I considered it not notarized, but it is a public document. However, it cannot be, for convenience and registrability, hindi magamit sa ROD. Okay, ano yan? Yung kasulatan sa barangay. Yan. Maraming iba kasi pag may kasulatan sa bentahan ng property or loan agreement doon sila sa barangay at authenticated by the barangay captain and the barangay secretary, duly sealed, no? Naman talagang barangay agreement or sa Bisaya pa, kasabutan sa pagpalit o sa pagbentahan or usapang bentahan sa lupa sa Tagalog. Yung mga things like that, to, kanya-kanya ang pagkano. Now, that kind of agreement is duly authenticated by the barangay captain and the secretary and stamped and sealed. This is considered as a public document emanating, nanggaling po doon sa barangay, which is a government subdivision, yung barangay natin, barangay unit, and it is considered as a public document. Kaya lang, the rule is that in order that it could be magkaroon ng strength ang kanyang at hindi na kailangan i-prove, no, na yung mga pirma ng mga barangay captain, everything. Kailangan po, merong kopya ang barangay kept on the records nila. The barangay secretary will be requested to keep a record para in case po, ipatawag po ng korte for subpoena duces tecum to bring the records of that file na nandun sa kanila, they could bring and authenticate or compare yung pinapakita ito kung the same ba, di ba? And that would be a public document. But for purposes of registrability doon sa registry of deeds, hindi pwede. Kasi ang kailangan talaga yung formal deed of sale na ginagamit natin, ginagawa ng abogado and duly notarized. No? But nevertheless, it's still a public document because it emanated from a government office or government subdivision, which is the barangay office. Yan siya, no? So, yes, or that, ang sabi mo dito, pwede ba bawiin ng mga heirs yung, or yung seller? Ito na lang, pwede ba bawiin ng seller ang title? Well, actually, consummated nga sale, so hindi pwede mabawi ang title, no? But, take note that in transactions like this, no, when it involves a title, and maganda sana kung na-notarize yun, no? And kung ipanotarize yan ngayon, hindi na magpayag ang lawyer niyan kasi patay na sila both. Wala namang lawyer magtanggap ng before me personally appeared. Klarong matatanggalan ng lisensya abogado niya. No? So that cannot be notarized anymore because the parties are dead. However, hindi po pwede kunin naman nila ang titulo balik. That is one indication that the title is under your possession. There was really a sale that transpired because in the first place, paano kayo may hawak ng titulo kung walang sale na transaction? And third, importante, kapag kayo ang in possession ng property, ibig sabihin, kayo ang nakatira doon, o hindi man kayo nakatira, meron kayong taong kinuha doon para maging caretaker or pinaparentahan ninyo. Ang possession kasi hindi ibig sabihin yung ikaw talaga mismo. It could be done remotely by other people. Pinaparenta mo sa iba, yan, possession yan. No? There is that kind of possession na it would show na you're exercising your right as an owner. So, pag yun ang mga instances po, yun po ang mag-solidify, mag-strengthen, magpalakas po sa inyong claim that there was really a sale that was made. Because in the first place, bakit nga naman nasa inyo ang titulo? At bakit naman kung kayo ang in possession, kung walang sale na nangyari? Meron talaga. Now, what is the remedy now in case kung sakaling siyempre, you want the property to be transferred under your name? Now, the question muna is that why was it not notarized? Siyempre, I think dahil magkakapatid ba, nakalimutan So we can ask for a court orders for to request for the issuance of yung parang an order that would direct the heirs to execute the necessary deed of conveyance. However, kung hindi sila mag-issue, the court may issue, no? May issue an order directing the registry of deeds na parang ito, this is a deed of conveyance. So, pwede mong gamitin pang gamit doon sa pag process ng pag-transfer ng title. However, the problem is that kung kailan ang date, possible ang penalties ang laki-laki na. Now, yan ang problem if you really want to transfer the title. Now, if you don't want to transfer the title, just leave it as it is. Hindi po tayo dapat matakot na magkaroon po ng possibility na kunin. Ang nakakatakot sa lahat is ganito. Kapag merong mag-lost title, hindi nyo alam. Hindi kayo. Alam naman, everyday kayo maging na certified true copy. Paano ko nakapag-lost title kasi sa pangalan pa nung kabilang party ng seller. What if kung mag-lost title yung heirs or yung seller side, no? Hindi nyo nabantayan at patituluhan at nabenta. So, the question is that, pwede ba ma-subject siya for what we call a parang adverse claim? Hindi. Hindi ka pwede mag-adverse claim because the title is with you and you have a notarized sale. So, ano ang mga remedy mo dyan ngayon? Dahil malakatakot ka, baka magpa-lost title. Anong pwede mong i-annotate sa title na there was a transaction? You could try adverse claim, but chances are it might be denied because on the ground, nasabihin natin hindi na notaryohan because that would be considered as laches or negligence on your part, no? You step on your rights to have it. Sila, yung mga parents. However, tingin ko naman is that kung karamihan kasing instances that the Registry of Deeds allows na meron pong tinatawag na adverse claim annotation is kapag yung titulo ko niya, nag-deed of sale kayo, tapos ang titulo hindi nabigay sa'yo, there is a danger that it may be the subject of a double sale. They will agree for an adverse claim immediately. Papa-annotate ka again na registry. Pero yung kasing danger na hinahanap mo, like for example, sabihin mo, baka kasi mag-lost title sila. That kind of assumption or kumbaga, assumption na mangyayari, it may or may not happen. Ang possibility of happening very slim because the rule is that para namang may tao bang gagawa kaagad ng kasamaan para lang makuha yung bagay na yan, no? However, in the case kapag may deed of sale tapos hindi binigyan ang title sa'yo, matataas talaga ang chance na possibly magkaroon ng double sale. For which kaya inaalaw yung adverse claim. Pero dyan sa situation na ganyan, itong sa situation dito Carlando, hindi. Possible, hindi. You have to go to court. And at least kahit pa paano, tatakan po ng necessary annotation of the title like dispendence, etc. But on that particular note, since hindi natin nakikita ang kompletong records and everything, I cannot give the exact kind of case that will be filed in court. So, dapat po isagunit na yan sa abogado ninyo. Immediately, ASAP, no? Dahil na ginademand ang titles ngayon with your lawyer para ma-protectionan po kayo. So, I hope you have understood that, Orlando, and human nature, no? Okay. Salamat, no? Let us see kung mayroon ba tayong mga kaibigan. Ayun. Si Wadas 5. Aloha, everyone. Hello, aloha. Wadas pala. Kamusta, Wadas? Si Caujus, good evening and Happy New Year, everyone. Si Jay, kumusta po? How are you? And si good evening, Attorney Alberto. And si P. Hi, P. Good evening. And si Merlita. Ayun, magkape na ito ngayon. Good morning, and Attorney and everyone. Good morning din po sa inyo, ma'am. And si Prodelisa Caparas. Good evening, Attorney. Thank you very much for learning a lot from all your topics. Happy New Year po. O nga, naubusan ako ng topic I would like you to propose a topic yung medyo yung nakakiliti ng utak din, no? For everybody to learn and ma-share natin, no? And si Happy New Year 2024. Wood dragon ngayon, no? Good dragon. Sino ba ang born in the year of dragon? And The best color daw of the year is orange. I do not know. It's just true. Huh? Okay. And si Johnny Vlog. Okay. Kumusta? And si Catherine and classmates, nakahabol pa ako. Baka kakastart ko lang, Kat, no? Na late din eh. And, yes, hello there. You're just in time. Happy New Year, sabi nga niya eh. Si Karen G, ito, mga friends. Kumusta kayo, guys? Teka tayo hindi nagkita, no? Kala mo, last year na. Yung pala, ilang araw na. Hermisa to be. Good evening. At maraming salamat po sa mga advice. Yes po. Yung iba, sorry kung meron kayong nag-chat ba kayo sa akin. Lately, hindi ako nakaka-open sa messenger ko. Medyo, maraming nagawa, no? Your family, continue your knowledge. God bless. Si Marites Medilla. Hello, Ma'am Marites. How are you? Okay, Alberto Medilla. How about the deed of sale that signature of the seller was forged? Ay, pag-forge po ang signature. Ay, hindi po talaga yan valid po, no? Pag ang ground is a forgery, it is an invalid document. It is a simulated contract that should be stricken down. Now, meron akong i-discuss sa inyo ito. That's a very good case. It involves marital consent. Alam niyo, nung unang panahon, before 1988, which is the Civil Code, and before the Civil Code than that, yung Spanish Civil Code, kapag ibenta ng husband ang property without the marital consent of the wife, the transaction is actually considered as voidable. Voidable, hindi void, Ibig sabihin, it will serve as a parang, the wife may have 10 years within which to nullify it, no? To question the transaction. But the laws stated there, klaro hindi spouse. Ang sabi doon is wife, husband, no? Kasi ang husband kasi ang presumed to be the administrator, no? Even now sa family code, siya ang parang masunod, no? So, kung ibenta niya without the marital consent of the wife has 10 years. Meron ng Supreme Court decision dyan, en banc, decided by the Supreme Court, na talaga nung panahon na yan, before 1988. Kaya maraming mga cases na hindi nakapag-marital consent. Talaga, makita mo sa deed of sale, walang marital consent. No? Pero i-compute mo ang time, from the time of the discovery of this, of course, siyempre, pag nagamit yun sa registry of deeds, doon nung bilangin yung 10 years, naglaps na ba yung period within which to contest it? Kasi, yung voidability ba? Kung naglampas na, prescribed ng action, hindi na mababawi, no? But, take note, to this time, under the family code, klaro po, void po ang sinabi ng batas. Void ang batas. Maraming conflicting decisions in that particular case. I just forgot the citation. But in that particular case, once and for all, sinettle talaga ng Supreme Court ang issue. Okay, nung panahon nung before the effectivity of the family code, pag walang marital consent, voidable. Okay, valid until annulled. But now, under the family code, klaro daw talaga na void kapag magbenta ng walang marital consent. So, yun. Now, kapag in that particular situation, nung unang panahon, pag may mga cases, ang ginagawa namin, so binibilang na namin yung 10 years, kung prescribe pa ba, pwede pa ma-question o hindi. Dahil pag wala na. That's the thing, no? So, I thought of discussing it here, pero medyo parang technically legal na talaga siya masyado ba for purposes of the consumption of the subscribers. So, hindi ko na lang i-discuss. But ngayon, kinakwento ko lang sa inyo bahagya para at least maintindihan ninyo. And, of course, with respect to the forged signature na seller, ayan, talagang void yan siya. Imprescriptible yan. Pwede yan siya ma-question at anytime, no? Sabi ni Pong Tinyo, attorney, ibinenta yung share ng heirs sa isang heirs din, pero need subdivided na ka-mother title. Pwede ba yon? Attorney, ibinenta yung share ng heirs sa isang heir. Okay. Take note ha, at the time of death, alam mo may magandang discussion about isang Supreme Court decision na nabasa ko na naman about death ba. Kapag namatay ba daw ang tao, may propriedad ha, decedent. From the time of death, by operation of law, heirs na kagad yung mga may-ari na kagad, co-owner na kagad yung mga heirs. Yan ang principle na i-discuss natin always, di ba? Kapag namatay ang ninuno, ang father, so automatic yung mga anak, pag sabing time of death, automatic maging co-owner na sila ng property. Pero mayroong mga discussions by the Supreme Court Justice, ang gaganda na discussion. Sabi niya, well, I believe in the principle that dapat it is the time of opening the succession. Hindi daw automatic. May mga discussions, no? Dapat kasi pag mamatay daw, that it means na pwede nang i-open ang succession. Ang other point naman, hindi, automatic co-owner na sila from that moment on. And they have to be protected already for any and all things na mangyari dun sa property. And the latter rule is the same pa rin, no? So, si Pong Tinyo, yung sabi mo, kung namatay, automatic co-owner sila. Wala pang subdivision nangyari sa isang lupa. Let's say, the property is 1 hectare. May 5 magkakapatid. 1 kapatid, ibinenta doon sa isang kapatid ang share niya. Pwede ba yun? Yan yung tawag nating intestate share. Pwede po yun. Kasi, co-owner na siya meron na siyang share sa inheritance. Hindi lang malaman kung saan doon. Kasi kung i-divide natin, subdivide natin yung 1 hectare. Parang tag 2,000 square meters sila. Pero hindi man pwede sabihin nung isang heir na yan ang 2,000 ko. Yan ang kahit na posisyonan pa yan. Meron nga nag-question sa akin sa comment section na isa daw, tayo na kagad ng bahay without consulting the others. Sabi ko, you cannot do that. They cannot do that because hindi pa man napag-usapan kung saan yung area na kung saan siya mag-share. But technically, yung nakabili, Pong Tinyo, yung nakabili ng share na heirs, 2 na ang kanyang share. Ibig sabihin, kung tag 2,000 square meters, 4,000 square meters na sila. So, tama po. Kailangan pa rin maggawa ng subdivision survey. Now, kung wala namang problema magkakapatid, they can always talk ba na, pwede man pag-usapan, kuya, ate, pwede po bang dito ako, baka yung 4,000 ko dito? Minsan magkakapatid, sige, wala problema, gawa tayo ng partition agreement. Subdivision survey tayo, pagkatapos partition agreement, pirmahan tayo. Wala problema. Ang problema kung meron ng problem na between among the siblings, away sila. Hindi magkasundo. Kung saan ang gusto ng isa, ayaw ng isa, alam mo, nangiinis lang. And usually the problems between or among the siblings usually happens kapag namatay na ang mga magulang. And that is what I'm always telling everyone na huwag naman sanang ganun. Because hindi man natin madala ang ating kayamanan pag mamatay tayo. They keep on fighting. Each of them getting lawyers, making the lawyers rich because malaki man ang mahal ang bayad. No? Yun ang problematic situation. But, whatever it is, in this particular case, kailangan ng subdivision, Pong Tinyo, no? I-subdivide po yung property, then either magkaintindihan sila, walang problema, mabibigay sa kanya. O kung hindi man, magbubunot-bunot yan. So, it's possible na yung tag 2,000 square meters niya na 2, maaring magkatabi, maaring hindi, kung nagbunutan sila. Di ba? O, ganun lang yan. Depende na lang yan sa ano. At the end of the day, kung mag-away din sila, pag magpunta sila sa court, ang gagawin ng korte, mag-order lang din yan ng bunot-bunot. Tambyolo rin yan. Paano ba? Wala man ang legal basis sa batas. Paano ba mag-choose? Paano ba mag-decide ang korte by saying na, okay, dahil matanda ka dyan, say, wala mang sanasabing batas ganyan. So, okay, mag-tambyolo lang tayo, bunot-bunot tayo. Ganon din, dapat nung hindi na lang tayo nagkaso. Bunot-bunot na lang tayo. Okay. Oy, si Frony Bato. Good PM bro. Pinsan. Oh, pinsan. Si Frony. Pinsan ko siguro ito. Yeah. I am, kung Bato na from Arayat, Pampanga, then yes, Frony. Yes. Hermes Too Big. May tatanong po ako, attorney. Bakit kapag merong nag-survey sa amin, hindi sila nagtatawag ng mga boundaries? Allowed po ba ito? Minsan, tiyatanggal pa po ang hindi po. Ganito yan kasi pag mag-survey, dapat kasi, the other adjacent, tama yun, tama yung point mo. Mali yung ginawa nila na, okay lang kung mag-survey sila, hindi kayo tawagin kung kapitbahay kayo, katabi kayo. No problem with that. Huwag lang sila magbunot ng muhon. That is not allowed. Because they can do that, because that is within their property. They could have what we call relocation survey. I-determine nila saan yung boundaries ba. Now, the moment ma-determine ng geodetic engineer ang boundaries, maglalagay lang yan siya ng flag. Flag na may red. Or kung semento, ang ginagawa nila, spray paint. Diyan sila pwede maglagay ng monument kapag may existing monument. Now, ang usual situations na binubunot at pinapalitan is kapag yung napatawag yung kabila, no? At mag-relocation survey ako kasi nawawala na yung muhon natin, natakpan na yata ng lupa. Pero sige. So pag survey, tapos hinanap yung muhon, ito yung muhon, no? Sabi niya, okay, naintindihan ko, no problem. Ilagyan natin ng bago or bunutin natin para maplastada kung saan talagang sakto. Kung the parties agree with that, no problem. Kasi yung pagbunot po ng monument, na yung muhon po is monument, no? That is criminally punishable under the revised penal code. May fine, may kulong yan. Hindi pwede bunutin basta-basta yan. Hermisa. Ako naman kung mag-relocation survey ako, if wala naman akong gagawin na sa muhon, I will do it on my own. Hindi na ako kailangan magpaalam. But the moment it would involve or practically have an effect on the other side or the owner of the other side, ay sasabihan ko sila. Kapitbahay Tawagin ko, in a nice way. Mag-relocation survey ako, I hope you don't mind. Pero wala man ako intention na iba. It's just that gusto ko lang ma-determine ang meets and bounds ng property. O sige, buti yan para mag-observe din ako kung anong talagang situation, di ba? Take note that engineers, kasi sabi na kasi engineer nila, inayos to. Hindi po, seldom wala pa ako nakitang engineers dito, is sa aking side, that would make ating favorable to the other. Sabi niya, ay, dapat palakyan mo sa akin or bawasan mo kanya. They do not do that. They will not, hindi nila isusugal ang license nila for that. And the mathematics is exact. Kung ano po meron po yun silang tinatawag na basis ba? Yung type point o tawag yung term nila na that would be their basis para mag-compute. Exact ang math exact ang science. So, hindi mo pwedeng i-change. 1 plus 1 equals 2. Diba? So, yan. Yan po ang Armenia. Happy hour of learning. Yeah, hey, Gertrudes. Kumusta si Gertrudes? Ano si Gertrudes? Bilib ako ito sa kanya kay ma'am ba? Hi, ma'am. Parati ito nag-comment sa akin. Parati nag-chat sa akin sa messenger. I'm so happy po. No? You keep on communicating and I appreciate it so much po. Maraming salamat. Catherine. Ito, magkaibigan to si Catherine, si Caujus. And for the Lisa Caparas, attorney, ask ko po ang emancipation patent po siguro na title ng lupa, pwede po daw po ibenta ang lupa. Lord Elisa, are you talking about emancipation patent? Kasi nakasulat dito, eminent patent to. So, I think emancipation patent ito kasi wala na ako maisip, no? Now, ano ba yung emancipation patent? Kumbaga, from the word itself, ang emancipation kasi, ibig sabihin, hindi ito sa lupa mo na, emancipation is that, yung parang ang isang underage naging of legal age, emancipated ba? Now, compared sa lupa, yung parang, yung walang lupa, nagkalupa. Parang ganun ang concept ng emancipation patent. Now, even before the Comprehensive Agrarian Reform Program in 1988. Panahon pa yan ni former President Marcos. Meron na po tayong pabigay ng lupa. Yes, meron na po tayong Department of Agriculture noon na nagbibigay. Meron tayong agrarian reform before, wherein they give land to the landless. These titles na binibigay sa land is considered as emancipation patents. And nung inanak yung Comprehensive Agrarian Reform Program panahon ni Cory, yung CLOA actually is also a kind of emancipation patent na binigay na merong restriction na 10 years. Now, if the emancipation patent that you are saying doon po sa panahon ni Marcos, pwede nyo ibenta yan. Kung sa CLOA naman, lampas na 10 years, pwede po ibenta ang lupa. No problem with that. Alright? So, hindi naman siya talaga seriously na problematic na. Okay. Tingnan lang po kung anong klaseng emancipation patent siya. Sabi ni P, attorney, ask ko lang po kung nag-submit ka na po sa prosecutor office ng case mo, mga how many days kaya po kami mabigyan ng summon po? Kung ako, nag-submit ako sa prosecutor at file lang kita ng kaso, parang ganun ba ibig sabihin mo, P? Ay, nako, depende. Depende kung anong area ka. Now, I will just speak for Davao City. In Davao City, siguro, in a month's time, regular filing bibigyan ka na ng summons to answer within 10 days. No? Submit your counter affidavit, the respondent. Understandably, ang dami po talagang trabaho ng prosecutor's office din. There are two kinds of investigation. No? Meron tayong tinatawag na yung natural filing and magkakandak ng preliminary investigation ang City Prosecution Office by requiring the other party to answer. Yan ang tinatanong mo. File ng kaso, pasagutin ng kabila, titibangin kung sinong tama, then kung sinong tama, kung tama ang complainant, i-file ang kaso sa court. Kung tama ang respondent, i-dismiss ang kaso ng complainant. Ganun lang. Pero meron tinatawag na inquest proceedings, kind of preliminary investigation also. Pero mabilisan. Yan po yung nahuhuli sa akto. Caught in the act. Yung warrantless arrest. Usually, mga bypass. Yan. May bypass ba? Let's say, nahuli caught in the act. Nagnakaw. Then, nakulong. Tapos, meron man tayo yung natawag nating 12, 18, 36, di ba? 12 hours, 18, and 36 hours na hindi pwedeng ma-detain ang preso, ang accused, yung suspect, without a case filed in court, in the office of the prosecutor's office. In court. Guaranteed man sa, Constitution. 12 hours kung yung mga less grave offenses, no? Pwede kayo detain for 12 hours na. Yung less grave offenses, slight offenses pa rin, light offenses. Tapos kung 18 hours, ang tagal na pwede kayo detain, less grave. Tapos yung grave felonies, yung 36 hours. murder. Kailangan may file ang kaso court. So, ibig sabihin, ng mga pulis yan, within that period, gagawa na yun ng mga affidavit complaint, kuha ng mga ebidensya, etc. And isasabit yan sa City Prosecutor's Office together with the accused for the suspect for inquest proceedings. Automatic, tatanungin niya ng prosecutor. Doon, harap-harapan niya ng piskal. Bilisan yan. Oh, ano ba? Gusto mo mag-submit ng counter affidavit? Hindi. Mag-submit ka, i-waive mo yung detention mo, continue ka ma-detain dyan. Pero kung hindi ka na mag-submit ng counter affidavit, hayaan mo na ako mag-resolve ngayon kung may kasalanan ka ba talaga o hindi sa batas. I-resolve ko ito within the time frame. Pag sabi niya, choice yun ng accused. No? Gusto ko magsabit ng counter affidavit, hindi ka na makareklamo sa 12-1836. Pero kung sabi mo, resolve niyo sir, wala man akong kasalanan. Pwede resolve ka agad. Well, the fiscal may find out na, prosecutor's office may find out na may kasalanan ka, dismiss kung wala kang kasalanan. Ma-dismiss kung wala kang kasalanan. Kung may kasalanan ka, mapapile kaso sa court. Yan yung direct filing ka agad. Though, later on, in fact, even during inquest, pwede ka man maka-bail, no? Kung bailable ang offense. Abot na ako sa criminal case. You know, guys, to be frank and honest with you, and before in 2008 kasi ako nag-start on focusing on properties. But before that, 2008, I was a criminal defense attorney. Focus ko talaga criminal cases. I love litigation. Hilig ako magharap sa korte talagang. 90% criminal defense attorney, 10% private prosecution. So, pakulong tayo ng mga estepador, mga rapists, mga ganyan. No? So, yeah, yun ang aking career starting 1999 when I passed the bar exam hanggang 2008. Naging interesado na lang ako sa property in 2008 nung the stress ng criminal cases took a toll on my health ba. Sakit-sakit. Hindi mo alam, binong doktor, ano sakit ito? Stress lang pala. Mahirap pag dinidibdib mo yung kaso. Ako, dinidibdib ko lalo na kapag alam ko yung kliyente is innocent. Talaga makikipaglaban ako sa kanya. And most cases, pati ako hindi nakakatulog paggabi. Sabi ng doktor, you have to change your focus. No? Or ayaw kong tawagin specialization. Sabihin ko lang focus. Attorney, you have to change your focus of field. Ayan, property ako. Enjoy din. But from time to time, hindi ako nakakatiis pag meron akong depensahan na konting criminal cases. Para just the itch ba? Yung katigani na yung maging criminal defense lawyer uli in court. Ayan, nakaka-appear pa rin ako ng criminal cases pa konti-konti lang. Makaka-prosecute konti-konti lang. But most focus ko is more on property problems, especially on real estate matters. Yeah, I'm just recalling those times. Kaya, si Piba, when I'm explaining, hindi ko mapigilan sarili ko mag-explain because, yeah, I really know the area of these criminal cases. Ganda ang criminal case. Kaya lang, stressful. Okay, saan ba tayo? Dito, sige ako chismis. Philip Andres, may CLOA title po kami pero walang land bank mortgage. Sa deed of adjudication ng lolo ko ay may OCT number siya pero di na ipasa sa new title pero 30 years na yung CLOA. Paano po ma-verify kung alang utang? Pwede po ba OCT siya dati 1920s? General na-convert to CLOA title noong 1994? Kasi kung naging CLOA siya, na-cover siya, Philip, no? Ang titulo kasi, kung may CLOA title kayo, ibig sabihin, yung OCT na-cancel na yon because it was covered by CARP, no? And it was distributed, no? Kunin yung retention na 5 hectares doon sa kung buhay pa yung registered owner, tapos pagde-divide doon sa mga anak na tagti 3 hectares, no? So, may CLOA title na kaya. However, ang sinasabi mo, di na ipasa sa new title. Walang land bank mortgage. Hindi ko alam kung bakit walang land bank mortgage. Baka kasi, yung title na hawak ninyo, hindi, sa inyo yan yung retention area na as registered owner. Iba kasi ang land bank mortgage kasi, yun yung mga beneficiaries. Yung nabigyan ng lupa. Yung mga nagtatanim doon, yung mga tenant ba. Hindi naman tenant yata ang discussion mo dito, Philip. Parang kayo yung landowner side. Wala talaga kayong land bank mortgage. Wala man kayo obligasyon magpenda sa land bank. Yung mga beneficiary ang may utang sa land bank. I-clear mo raw, Philip, and I will answer you. I'll get back to you. Okay? Bakit kaya owner pa nila ang title kaysa tax declaration? Bakit kaya owner pa nila ang title kaysa... Well, title kasi kayo may torrent system of registration tayo. Yan po yung system ng registration sa registry of deeds na pagpatunay na you have the best evidence of ownership, which is the title. Sabi ni Catherine, attorney, ask ko lang po, CLOA title, namatay na yung may-ari, yung husband niya, sinangla ang lupa sa ibang tao. Ngayon, gustong bilhin na yung lupa nakasangla. Pwede po ba yun matransfer sa taong? Well, ganito kasi yan Kung CLOA na title, namatay na yung may-ari, tapos yung husband niya sinangla, ibig sabihin, namatay ang spouse. So, ang husband buhay. Ayun sa title is married to sila, di ba? Kanila yon property. Sinangla niya. Well, in the first place, ang pagsangla nun, questionable because may mga heirs, di ba? You cannot mortgage a property that hindi naman totally sa'yo lang. Meron mga heirs. So, void po yan, no? So, hindi ba basta-basta pwedeng matransfer sa ibang tao na because na sangla? Kasi, kung magawa siya real estate mortgage, at the end of the day, extrajudicial with real estate mortgage, hanapin niya mga heirs. Hindi man nakapirma sa real estate mortgage unless pinorge or pinapirma rin sila. Attorney, perjury makakakuha ba ng criminal and civil claim po? Criminal and civil. Okay. Perjury. Well, ang perjury kasi, it is a kind of crime that would that there could be no private offended party, possibly, except that if the perjury made nagkaroon ng damage doon sa other party na irreparable. That's why we could claim for a separate action for damages. Take note marami tayong klaseng perjury. Perjury on paper. Meron tayong perjury on subornation. Meron tayong perjury na yung kind of perjury, yung false testimony in court. Siyempre, sa false testimony in court and nag-false testimony siya, tapos napatunayan, tapos yung pala, hindi totoo, tapos because of that, nakulong ka or in everything, then you could file an action for criminal case plus civil case for damages against that person. Iba naman, sa sulat, na perjure nila yun sa affidavit nila, tapos nailipat ang title, tapos kung nag-cause ng damage, pwede ka na kuha ng damage. Separate action talaga siya. Iba ang perjury. Maraming pagsisinungaling na covered ng word na perjury. I believe the citation of the case you were referring to and the time of death beyond survivors. Ito yung Treyes versus Larlar. Yes. Is that the 2021 case, no? I think, talaga si CJ, talagang, to siya ba? Updated sa mga cases. Thank you, CJ. So, it's Treyes versus Larlar. Kasi nabasa ko ngayon, hindi ko kasi ma-open. Actually, pag nakakabasa ako ng Supreme Court decision, Meron ako isang folder sa Word, dito sa aking computer. Sinisave ko sa personal drive ko for Supreme Court cases na good read para mabasa-basa ko. Then I also give it to my associates for them to read. Thank you so much sa CJ, ha? I'll call you CJ. CJ Caudius or Chief Justice. Thank you so much. Nanding, maayong gabi. Ito, taga Cebu natin na kaibigan. Kung ipatitle ang unregistered land kay tax deck ang property na na-inherit, ngayon, kung ipatitulo na sa RD, judicial titling ba required? Hindi. Pwedeng judicial, pwedeng hindi judicial. Pwedeng administrative titling. So, kung if meron kang unregistered land, tapos sabi mo is alienable and disposable to siya, tapos may tax deck, no? Tapos, dahil na-inherit niya yung property, kailangan ng extrajudicial settlement of estate, tapos i-transfer yung tax deck sa pangalan nung naka-inherit at bayaran estate tax at iparegister doon sa Registry of Deeds. And yes, no, alam natin yan, no? Unregistered lands, merong libro din ang Registry of Deeds na mag-enter sila doon. Mga sale transactions or transfer transactions ng unregistered lands doon yan sa tawag nito sa Registry of Deeds. Tatanggap yan. Now, magbibigay sila ng certification na merong na-record na nila na entry. Bibigay nyo yun sa Assessor's Office para malipat ang tax deck under the name so naka-inherit. From there, you could now file for what we call administrative titling. No? Depende. Ano mo, agricultural patent, homestead patent, or residential patent. Depende. So, apply ka doon. Pwede rin judicial titling kung gusto mo. Wala mang problema. That's allowed naman. Okay. Attorney, sabi ni Oscar, if the SP is forged, is the deed of sale is also void? Yes. Kasi, ang source niya is void. So, yung spring is also void. Kaya sabi nga nila, the spring cannot rise higher than the source, no? From the source, no? Kasi, ang source niya is sira na. So, siya rin, sira na rin. Void din po ang deed of sale. Kung sa probated na last will, ngayon magparehistro sa Registry of Deeds and tax deck na unregistered farm lot, di ba applicable ang pagparegister sa agrarian administrative titling? Teka, kung under probate ng last will, tapos hindi siya. Kumbaga, para sigurong, that's the problem of the administrator. Merong isang last will na unregistered land. Pagkatapos is that ang may-ari nito is yung mga nasa last will and testament. In order to have a title, kasi trabaho yan ng administrator, I would agree kung sabi mo kasi agrarian administrative titling po, kapag na-cover po ng CARP, pero kung hindi siya na-cover ng CARP, then you go to the DNR. Okay? Yun lang man ang conflict of jurisdiction nila eh. Ang DNR kasi, they cover all lands, no? Agricultural lands, they cover alienable and disposable agricultural lands, residential, everything. Ang DAR, covered agricultural lands lang. So, if it is covered already by, pag sabihin covered na-carp siya ba? Although wala namang covering ngayon, no? Coverage, no? It's more on distribution naman tayo at payment, no? Sa landowners. So, depende kung covered or not covered siya ng DAR. Kung hindi siya covered, then you go to the DNR. Kung covered siya, then you have to talk to DAR kasi baka may tenancy issue. Kung may tenancy issue, isa-settle niyo muna ng tenants bago ma-divide yun sa mga heirs. Depende, nanding. Depende kung covered ba siya o hindi. Can we claim back the property with a void deed of sale? Well, yes, of course. If the deed of sale is void, then you could file a case for, let's say, nullification of sale, nullification, cancellation of title by reason of a void deed of absolute sale. Ganun ba? Pa-nullify yung sale and title. Kasi, void eh. Forged eh. Oh, tile line. Gertrudes. Thank you, Gertrudes. Tile line. Tile. Tile point. Tile point. Tile line, Gertrudes. Thank you so much, ma'am. Tile line. Yes, yan po ang basis. Ferdinand Valencia Imperial, good evening. Good evening also, Ferdy. Kumusta? Naka-tune in ka, ha? Ayan, si Ferdy si Emancipation Patent. Okay, cool. Hello, o si Life in the Yard. Kumusta, Lifey? Okay. Okay, si 6 o'clock, si Hazel. Kumusta? And si Marites, tanong niya. Sige, magkwentuhan muna kayo dyan, Hazel, Caudus, Life, ha? And Merlita. Attorney, pwede po ba mag-execute ng deed of extrajudicial settlement na may kasamang waiver of rights in favor of third party, not compulsory? Oh, yes, wala problema. That can be done. Hindi naman yan siya violative of any law. But that kind of waiver, hindi proper term ang waiver niyan. It's called parang donation yan actually. Although if you use the word waiver, kukumpitan pa rin yan ng donation. 6% donor's tax and 1.5 DST. Binigay mo sa iba, binigay mo sa iba. Yan. Ibig sabihin po niyan is donation po yan. Kadalasan ngayon, pera-pera lang. Well, if we will always abide on the rule on pera-pera lang and sasabay tayo doon, we do not become an example to the people and to our children, to everyone else, then susundan lang din tayo. It would be a same situation ba? Whereas if you do it right, try to become a model one, and people will follow you, magkakaroon ng domino effect din. Ganun naman yan. So, hindi talaga din maiwasan. In a system of power governance, anywhere in the world, nandiyan na talaga yung corruption. Pera-pera talaga. That's how it is. But, of course, they chose that side. Okay. Ako naman, I choose this side. Dito ako. Hindi ako nagmamalinis na I'm saying 100% na, di ba? But, ang importante yung wala kang tapakan na tao. Wala kang tapakan. Kasi pag once magtapak ka, ay, ang karma, babalik yan. Yan lang ang sabi ng dad ko. Just don't step on others' foot. Yolanda, good day, attorney. 1 year na rin po ako sumaybay sa YouTube. Uy, thank you, Lomat, Yolanda Magtoto, ha? Parang si Yoli, kilala ko ito ba? Magtoto. Yeah, meron ako client na Magtoto. And si Butaw Budi. Oh, ito na yung ating sa Pusoy. Happy New Year. More power to this channel. Yes, Butaw. Thank you also for always being there, ha. From Quezon Province po, si Carmelo Deseo. Guys, a new subscriber ata natin, si Carmelo Deseo. Salamat po. And attorney, may one lot na naisama sa total handholding sa assessors pero kapangalan na pala walang middle name. Paano ipa-cancel sa EGS na babayaran? Paano ipa-cancel sa EGS na nabayaran na BIR? Problema kayo niyan, bako ipa-cancel mo, wag mo na ipa-cancel yan, tapos magkuha ka ng parang tax credit sa BIR, taas na proseso. Kung nabayaran mo na, ang proper way is talagang, siyempre, pa-cancel mo yung tax credit, kuha ka, bawiin mo sa BIR, at taas na proseso. Can do that. And transfer fee, maniningil ka na naman. taas din na proseso. Dahil hindi yun kasali. Ako, sabit ko na lang sa ROD. Tapos, ako charge to experience ko na lang. Kasi kung magko-collect ka, I have an experience from one of my friends na naghingi ng reimbursement. Ang tagal, masyado. Super tagal. Tapos, sometimes, pinapa-apply na lang, parang tax credit, hindi talaga yung ibibigay pera. Sige, sa next tax mo na lang, i-deduct na lang. I hope. I don't know. Pero kung gusto mo talaga, may procedure talaga. But I am not a tax expert eh. So, you have to ask how to do it from a tax lawyer. Marami rin nagpo-focus dito ng tax lawyer. Karamihan, alam ko, nagpo-focus ng sa practice namin sa law. May mga tax lawyer, merong yung intellectual property law, and criminal law. So, doon kayo sa tax lawyer expert. Si Philip Andres, landowner. So, Philip, yun nga. Wala talaga kayong utang sa land bank kasi landowner man kayo. So, with that, na-carp ang property ninyo, yung OCT, kaya na-cancel si OCT. At nabigyan kayo ng mga CLOA titles as landowners. Siyempre, bibiakin yun eh. Kayo naman, yung ano yung retention ninyo at para sa mga heirs, yung 33 hectares sa mga anak, bibigyan din ng titulo ng DAR. Plus yung nakuha na lupa, babayaran kayo. And yung nakuha na lupa, i-issue ng title doon sa mga beneficiaries. Now, that title of yours, since meron na kayo, try po kayo maghingi ng certified true copy niyan sa Registry of Deeds. And you will see that you will have a certified true copy ng mga CLOA titles ninyo. Dapat lang malaman ninyo kung magkano ang retention ninyo, gaano kalaki ang retention niyo, plus kung nabigay ba. Kasi usually ang retention, kunyari, may mag-registered owner, mag-asawa na nakuhaan, may retention sila. Yung mga anak bibigyan kasi 33 hectares. Sige, check mo, ha? Kadalasan ngayon, ang favor sa court, ang may mga private attorney, may influence, may position sa government. Well, actually, case-to-case basis lahat, Maria, gabi na yun. Mind you, yung mga crimes talaga na hindi naman kayo nagkukuha ng mga private prosecutors, kasi meron man tayong prosecutors yung government, no? DOJ, na nakakapagpakulong din sila on their own. Private prosecutor comes in lang usually to protect the civil claim, yung monetary claim noong private offended party. Basically, tandaan niyo ito, pag merong kaso, kaya nga may government prosecutor because ang normal offended party technically is ang government eh. Kaya nga people eh. People versus Juan de la Cruz. Ang buong mamamayan, ang buong sambayanan, ang gobyerno ang kalaban mo. Kaya mayroong government of. Now, if you're the victim, na nakawan ka and everything, ang interest mo lang dyan is to recover the damage noong nawala sa'yo. Nawalan ka ng mga diamonds and everything. So, recover mo diamonds plus damages. Incidental na sabihin mo na ako ang witness for the state, yes. Pero hindi ka po ang kalaban criminally. Ang kalaban talaga noong nakulong or makukulong isang gobyerno. Witness ka lang po ng state. And sometimes, papasok si private prosecutor, pasok kami. And we are allowed to prosecute also. May batas man na, sige sir, ikaw na lang mag-attorney, ikaw na lang ang mag-prosecute niyan under my supervision. Or sometimes, pag medyo patagal ka na sa practice, binibigyan ka ng authority to prosecute ng city. Kaya may tiwala na sila ba na kaya mo. Then when you prosecute, ikaw na mag-prosecute. Kunyari, ikaw na ang government prosecutor, and at the same time, you are also protecting yung civil claim ng private offended party. So, yan ang situation. Pero there are cases kasi na hindi naman kailangan na ng private prosecutor, pwede mag-proceed pa rin. Both the criminal and civil aspect of the case, makukuha din ng government prosecutor yan. Dito sa amin sa Davao, magagaling ang prosecutors namin dito, mababata, tapos mga pao namin, mababata, galing minsan nga masaya tingnan ang DOJ at pao magbanggaan dito sa amin sa Davao, talagang, lapad talaga. Tapos pag medyo, ang maganda dito, kapag tagilid ang kaso ni Pao, tagilid yung, kasi hindi naman makapili ng kaso eh. Kung talagang yung i-defend niya na akusado is talagang nagkasala. All evidences pointing towards that person. Ano ba magawa niya? So, ang pinaka-the best niya magawa is, ng pamatulong is ipaplead ng lesser offense para mas mababang sentensya. Baka maka-probation pa. Ang prosecutor's office naman, sometimes, pag makita niya na ang evidence nila kulang-kulang na rin, hindi rin makakonvict, then sometimes they agree for some provisional dismissal. Ganyan technique yan. No? Pero yung sabi mo kasi na favor sa court, I do not know kasi ako, I always believe that if you present your case-to-case basis, at kompletong kaso mo, the judge cannot think otherwise to rule against you kung sakto ang kaso mo. I think, sakto ang ebidensya mo. Natatalo kasi kapag mahinang ebidensya or kulang ebidensya. Yan po ang po namin as lawyers, yan po ang aming kumbaga very important sa amin yung evidence. Ako pag, let's say, mulapit sa akin ng client and say, attorney, meron nag-ano sa akin, nag-issue siya ng cheque, ng utang, nagpakulong ko yan, ganun, estapa, etc. Ganun. Sige, sabi ko, pailan natin ang kaso. Oh, okay. So, tanong ko sa iyo, ganito, paano kung pailan natin siya kaso, hindi siya makabayad dahil wala siyang pambayad? Okay lang sa iyo, ipakulong siya. Kasi baka ang gusto mo makabayad. Kasi what if kung hindi makabayad? Bakit attorney? Kasi what if kung wala tayong ma-execute sa kanya, wala siyang properties, wala siyang pera, wala siyang pera sa bangko. Okay lang. Yan. Pa-explain ko muna. Ang expectation ba? Kasi tapos alam nyo, gagastos po kayo ng private attorney. Siyempre, magbayad kayo na. Tapos kung i-demand natin for that person to pay the reverse of the attorney's fee, malamang hindi rin makakabayad. Okay lang sa inyo. If you really want to seek justice, ano ba talagang gusto nyo? Effective. So, well, case-to-case basis. Oh, Merlita, January 27, 2024. Yeah, dito ba yun sa Davao? Kasi yung Manila ko, I was told that my examination, nag-masters po kasi ako, examination will be announced, but my graduation will be on March. Definitely, I'll be in March. Sa March po, nasa Manila po ako. But if January 27, 2024, hindi ko alam kung are you talking about here in Davao City, then I'm just here in Davao City. No problem. Ano ba yung araw yan, January 27? Check ko muna yung calendar natin. Yan ba yung usapan natin, Merdita, na dito tayo sa Oh, that is Saturday. Saturday, yes. So, wala akong hearing, oh. Okay. Sige. Sa palagay ko po, na-covered lang ang lolo ko nung carp tapos na-transfers na sa nanay ko, clue title na. Okay po. At least we are clear about that, Philip. Tama ka po dyan, attorney. Kahit ako, na-stressed ako ng gusto sa kaso kasi alam ko namin ang lupa at kaya kadalasan nakaramdam ka ng sakit sa katawan. Alam nyo, Niwala kayo sa hindi. Whether you're the complainant, even if you're the complainant in a case, kahit panalo ka pa, stressful po talaga magkaroon ng kaso. The fact na kahit na plaintiff ka in civil case or complainant ka in criminal case, alam mong mananalo ka and everything, stressful po. Unless, yun pong, mahilig ka talaga sa kaso. Sanay ka sa kaso at sanay ka mang away. Yan, parang ang life mo is masayang-masaya ka makipag-away. Ayan, that's a different thing. Talagang okay lang yan. Walang stress. Stressful talaga. Kaya, I always tell my clients, sabi ko, well, ano ba? Gusto mo ng kaso? Can we talk and can we somehow agree na baka pwedeng aregluhin ninyo? Basta, kaya pa aregluhin ang problema. Kung hindi na kaya aregluhin ang problema, then, talaga, kaso natin. Baka pwedeng pag-usapan ba? That's how we could help, I could help you na less stress. Sabi ni Bernie Puentes, at binenta po ng wife niya yung lupa na deceased brother namin. Po silang dalawang anak na minor. Pwede po makakuha ng anak yung partner. Well, actually, kung ganun po is, kailangan pong, mapwede naman, no? Isang guni mo yan, Benny, sa lawyer, in order to recover what is due to the children. Kasi kung binenta nga, hindi naman pwede mabenta kung may minors, no? Kailangan kasi ng court order. Pero isang guni nyo sa lawyer. Okay, so, what time it is? Bakit wala akong oras? So, the time is 7:30 na pala. So, guys, I think we covered some time na. Medyo ano pa, no? I'll answer a few more, ha? Yung iba, kindly message me ngayon sa Messenger. Attorney Raymond ba ito na Messenger? Message request check. Tapos magtanong na kayo ngayon sagutin ko na lang while I'm having my dinner with my family. Wala man, di ba? Kami maglakad ngayon. So, mag-chat-chat na ako sa inyo. Okay? So, muna ako. Bye-bye na muna ako sa inyo, guys. And I will see you again next week, no? And, yeah. Thank you so much for tuning in. And Hazel and everyone else, Mardita, kayo na pong bala dyan, ha? Sikaw Juice. Chief Justice or Chief Juice? CJ is fine. Okay. Thank you so much. Hernando Barrier pala. He was exponente. Okay. Sige, salamat ka, CJ. Meron na bang ang 1190s IR? Meron na po. Robin Hugo, meron ng IRR. Yung I think na-present ko na yun. Meron na ang BIR Revenue Regulation. Na-discuss ko na yan sa lecture ko. Doon na yun. I shared the revenue circular or revenue memorandum ng BIR on how to do it. Carmelo, i-chat mo. I will answer you later on, guys, ha? So, bye-bye na talaga. Sige, bye-bye, guys. Thank you so much for tuning in.